I think I've counted all the lawyers. There should be 5 up there. Yep, I see you. Have the attorneys for the appellees figured out how you're going to use your time? Somebody? Can you not hear me? Hello?
Dennis, you're on mute.
Hello? Can you hear me?
Yes,
Mr.
Judge
O'Connor,
Marcotte, we can hear you. Mr. Connor,
Okay.
O'Connor, can you put your mic,
I
unmute your
see.
mic?
Mr. O'Connor, you're on mute. Modern life.
How about now? Can you hear me okay?
Yeah, I
All
can
right.
hear you. Yeah.
Your Honor, can
Are
you
you
hear me?
the elected spokesman?
Well, I drew the short straw.
Okay.
And yes, we have we spoke yesterday about the allocation of our time.
Okay. So when I call you guys, you'll know what you're doing.
Yes, sir.
All right. Okay. Who are we? Mr. Shannon, you're up.
Thank you, Your Honor. Good morning, and may it please the court. My name is Nick Shanine, and I represent the appellee in this case, Joy Benedict. I would like to reserve half of my time for rebuttal, given that I have 4 counsel that are opposing me, and I'm not sure what they're going to do. I'd better reserve a little extra. Thank you, Your Honors. With that, I am going to ask this court to reverse a summary judgment that was entered erroneously against Joy Benedict, a teenager who was hit on her bicycle by a van that was emblazoned with the logos of Comcast, a cable providing company. That van did not stop when it hit her, but proceeded on. Fortunately, a Good Samaritan assisted her, and the van driver did call 911, which resulted in us knowing the facts that were needed to proceed with this case. The case proceeded through discovery and got to a summary judgment hearing, and the court took detailed questions and answers and entered a ruling that made it very clear that that court was not granting summary judgment as to issues of employment, finding that, is there a question of fact here? There is. There just is. The court.
Let me ask you, Mr. Shannon, all of the appellees argued on the employment issue.
Sure.
And they have raised that in their briefs on appeal. I mean, are they not in the position to argue essentially that the judge was right for the wrong reason?
Absolutely, Your Honor. The tipsy coachman rule is certainly permissible. The Miami-Dade County versus radio station case, et cetera. So there is no doubt that they are free to argue an alternate basis for why the trial court was correct, even if for the wrong reasons. We believe that the trial court was correct on that ruling, and that the argument that was contained both in the initial brief and in the reply brief helps to rebut that position and establish that the trial judge, relying on cases such as Harper from this court, clearly found that there was in fact an issue of fact as to employment. And to that point, there was evidence before the court of no fewer than 11 different factors that would support the idea that Mr. Ricketts was an employee of, Comcast. But when I say Comcast, RWL supplied a nice chart on page 3 of their brief, and I thank their counsel for doing so, because it spells out a lot quicker than what I could explain how the lineage goes that gets you 4 appellees. But Comcast sublet its responsibilities to RWL, who sublet to Capital Telecom, who sublet to Cable Guys, who then was the direct employer for Anthony Ricketts. But all of the people up the line are the individuals responsible, and I'll let the defendants explore that more with you if they care to do so. But there was no question.
What I'm saying is that you had a difference between what the judge said at the hearing, and then you had the final order. But it seems to me that it really makes no difference if they were correct.
I agree,
if they can convince us that those other reasons were correct.
That is correct, Your Honor, and that's the way I considered it with that they were free to bring up this issue as a tipsy coachman issue. And if they prevail upon you that the logic is sound for it, then this court may affirm on that basis. We simply believe that it does not apply and that the trial judge was correct on that issue. Where the trial judge was not correct was on his decision that a concept that originated in workers' compensation, the going and coming rule, applied in such a way to obviate the potential for liability should a jury so find it. And we've expressed the reasons throughout the briefing why, and in the argument below, why the going and coming rule is not applicable to this case. And those reasons are several. The first of them is that, as I mentioned, it's a workers' compensation rule. And when we're talking about tort law, there's fundamental differences in standards between workers' compensation and tort law. And I actually do a fair number of comp appeals. And every time I do, I scratch my head and wonder why I agreed to take that assignment. But they are interesting cases, but they're cases with very different logical analysis because of the trade-off that occurs in workers' comp that doesn't occur in tort law. But when applying tort law, the case of Sussman is the applicable decision that helps us to know the Sussman factors, and the defendants refer to the Sussman case as well. And it's simply this, that if I, as a lawyer, am traveling to work, but my work is at my office back before COVID and I could go to the office, but if it's at my office, then I don't get to count as an employee simply traveling to work or coming back from work. However, if my travel is something that the conduct of the kind of the employee is hired to perform, if it is the conduct occurs substantially within time and space limits authorized, and the conduct is activated at least in part by a purpose to serve the master, then it does apply. And this court's decision in Kane Furniture Corp helps to clarify that. And the three prongs are all easily met in this instance. That here we have a traveling employee. His whole purpose is to go house to house, installing Comcast wares and making sure that the customers can receive the signal, et cetera, so that they can pay a monthly fee to Comcast, and Comcast can have its various subletting employees, profit from that. And so there's definitely a purpose to the traveling, and it's the kind of conduct that he was hired to perform. And specifically, he was hired to come to that office to get work orders, take those work orders, go out to the houses, do his thing, and then has to return to that office at some point to return those work orders and to return the unused equipment. And so when doing all of that, he has to, as part of his job, travel to that particular office, even though that office is not where he works. He works at all the various homes that he travels to. So the conduct is the kind that he's hired to perform. The conduct occurred specifically or substantially within the time and space limits authorized. His routes were all around that office, and the time was right before he would start his work shifts. So that all matches. And the conduct is activated at least in part by a purpose to serve the master. That's a clear check. He was not traveling to go get breakfast or traveling to go to a nightclub or something. He was traveling to go return the day before his work orders, to return the service equipment, and to get his new work orders. And all of that is clearly activated in part to serve the master. And the first DCA in a comp case even said that where the evidence adduced, and this is the case of Stanley versus Johnson, if the evidence adduced in the summary proceedings is believed by a jury, well, okay, that can't be a comp case then, but it's a first DCA case nonetheless, is sufficient to show that Johnson was rendering a service for his employer sufficient to impose liability, even though he was on his way to work and not being compensated at the time of the accident. The last piece of that is so Stanley would make it clear going and coming should not have applied here. But in this instance, there was testimony that he was compensated as part of his compensation for the travel required to and from the office as part of his arrangement. So all of these factors combine to make clear that we have the Sussman factors, and the court simply got it wrong on whether or not the going and coming rule applies. However, even if we use the workers' compensation standard, there were two different factors as to why that rule still doesn't apply. And most of those factors really dovetail into Sussman anyway. The concern about whether this is tort law or workers' comp law really doesn't, isn't the hinge upon which this door closes, because either way, it's very clear that the coming and going rule should not apply. But if we do apply work comp law to it, then you have two different clearly codified first DCA ratified exceptions to that coming and going rule. And the first is a traveling employee. Well, hello, this case is the ideal example of a traveling employee. That's what he does.
If a traveling employee has an appointed time where he has to be at work before he does his traveling every day, can the traveling employee exception to the coming and going exception apply at that time?
We believe that the Longo decision cited in the briefing makes clear that he's still a traveling employee, even if he has a generally set time. But even that set time isn't that set. That we heard the briefing or read the briefing that he was allowed to come in the night before to drop off those work orders.
Well, he was allowed to come in the night before to drop off the work orders, but he still had to be at work at an appointed time in the morning to get his marching orders for the rest of the day.
That is correct, Your Honor. And so it would be up to this court to decide whether that exception applies to the exception of the traveling employee. But we would argue it doesn't. But even if it does, then the dual purpose rule definitely comes into play. And the dual purpose is if you had two purposes in coming to work. One is to come to work. Okay, so let's say we accept the exception to the exception, and that just getting there for that appointed time meets muster. If so, then if that was his only reason to go, I'm going there because you told me to go here as my start of my day, and then I go. But instead, he had two other things that he was doing. He was returning those prior work orders, because without those prior work orders, cable guys doesn't get Capital Telecom to pay them, who doesn't get RWL to pay them, and that won't make Comcast happy. So that was definitely part of it. And then the second thing he was doing is returning equipment. People don't normally haul around cable equipment for fun. It's not a personal thing. That's clearly a work thing. And to deliver that to the company required him to do that. And this is what he was doing at the time. His van ran into the bicycle driven by Joy Benedict.
And Mr. Shanine, you are now at 10 minutes, so you proceed as you wish.
In which case I will, I think that was a good stopping point. I've covered the bases, and I will let able counsel take it from here. Thank you, Your Honor.
Okay, thanks. Okay, somebody from the appellees gonna.
Judge, because I drew the short straw because of the length of Mr. Angel's brief, we decided that I would get to go first, and I'm Dennis O'Connor for RW.
Yeah. So what are you guys gonna do time wise?
We're going to just play it by ear, go with the flow in terms of your questions and the topics you raise, and we'll yield to each other. Generally, we're going to divide up the time equally, although I think some of the appellees don't care to use much time at all. Is that okay?
Yeah,
Is that right?
fine.
All right. So I'll call.
I'm not big on strict rules like that.
No objection, Your Honors.
We didn't know how to handle. We actually talked about it. So I'll call the four appellees with a nod towards the return of college football, the group of four. And I represent RWL. And as I read the briefs, and I wasn't present in the lower court, but it occurs to me that while there were three theories of liability alleged against RWL, the only theory that's being pursued on appeal is respondeat superior based upon course and scope. And that's what I'll speak to. And I do agree that Mr. Angel's graphic is very helpful, and it demonstrates just how far downstream Mr. Ricketts was from RWL. 3 contracts removed. And the very case that Mr. Shanine relies upon, the Stanley case, sets forth basically the rule. It says that the well-recognized rule that an employee driving to or from work is not within the scope of employment so as to impose liability on the employer. Now, in that case, the gentleman went and got gas for his mower, and he was responsible for doing that. But it articulates the very rule, which takes us to what I will call the Sussman test. and Mr. Shanine talked about Sussman. And so there are three elements to the Sussman test. And so number one, he was not hired to drive, Mr. Ricketts was not hired to drive to and from his residence. He was hired to start his day at the warehouse, pick up his orders and equipment and go to the homes. So that failed. This accident happened while Mr. Ricketts was driving from his home to the warehouse. It was for his convenience that he was permitted to return work orders and cable boxes. And this is an interesting case. It gives us some insight into the cable industry, but it's not sufficient to survive. That interest and intrigue. And
So let me ask you this, Mr. Connor, does it make any difference? I mean, I gather that your client is the one that assigned the work, correct?
that's not clear, Judge, from the record.
I mean,
My client was certainly.
If Mr. Benedict was given a work order, he was given the work order at your client's facility by your client. I gathered from the briefs, your client had employees and had these, what it perceived to be contractors, correct?
That's correct. Three.
So we would receive it. Did it make a difference that he hadn't received any work orders yet for that day? Well, I mean, is that the setup? He would receive them once he got there?
Right. His day had not yet started, Judge. His work day would have started once he arrived at the warehouse and received his instructions for that.
Okay.
And he was contracted with cable guys, who in turn contracted. Now we're going up. We're fish swimming upstream. Who contracted with Capital Telecom, who contracted with us. So the first prong is not met. The second prong, this accident did not happen while Mr. Ricketts was driving from the warehouse to Mr. Smith's house in Lee County. It happened before his workday even started. And when the accident happened, Mr. Ricketts was not doing something motivated to serve his master. That's the third prong. And Mr. Ricketts was an independent contractor. Mr. Ricketts was his own master. So for those reasons, Judge, we think while getting some behind the scene insight into how the cable industry works, we think, and while we wish this hadn't happened, we feel badly. We don't know the nature and extent of this young lady's injuries. She may have recourse against Mr. Ricketts. She may have recourse against other insurance policies, but just because you can name and identify a corporate defendant does not create a cause of action. It certainly is not sufficient to survive summary judgment. So unless the court has any additional questions for me, I will yield to the next member of the group. Thank you all very much.
Thank you, Mr. Connor. Okay, for the rest of you, there are 16 minutes left on your side. So somebody can pipe up and proceed. I really have no preference.
Hey, please, the court, I'll go ahead and jump in. My name is Ezekiel Lugo, and I represent Appalachia Cable Guys Communications, Inc. This morning, we request that the court affirm the order on appeal for three reasons. First, the appellant cannot show there was error as to the application of the coming and going rule. Second, the two exceptions cited by the appellant do not apply. And third, the appellant has not challenged the other basis or described in the court's summary judgment order. Turning first to the point about the application of the coming and going rule, the argument in the initial brief centers on the assumption that the trial judge applied workers' compensation cases when it decided the going and coming rule issue. But the record does not indicate that the judge in fact did that. So that's problem number one for the appellant. Problem number two is that even if the judge had in fact relied on workers' compensation cases, the law in Florida, the law that applies in Florida, generally allows the trial courts to rely on workers' compensation cases when looking at the going and coming rule, because as the 11th Circuit Court of Appeal noted in the Jones case, the workers' compensation statute codifies the common law on the going and coming rule. So the 11th Circuit Court of Appeals has already rejected that argument, and cases from the Florida District Court of Appeals have relied on case law interpreting that statute in tort cases. And that includes the Adams case from the 5th District Court of Appeal and this court in the Thorston case as well. So,
Mr. Lugo, before you get too far ahead of me, I'd like to go back to our case by Judge Campbell and Fierro, where we adopted the Sussman rule. My understanding is the third prong says motivated at least in part by a purpose to serve the master. Please let me know whether I am constructing it correctly. In this case, Mr. Ricketts is driving arguably to the location of RWL for multiple purposes, one of which is to see if there's any jobs opening today that will not be filled by RWL employees. Number two, to turn the work orders in that he completed the day before, which would arguably result in payment to cable guys. And three, return the equipment, which would allow cable guys to be in compliance with their contract that goes upstream. Since this is a summary judgment matter, is there enough dispute and evidence that on this theory, arguably the trial court erred and it should go to a trier of fact?
No, Your Honor. The Fierro case relied on Sussman to reject not the coming and going rule itself, but the exception, the traveling exception to the going and coming rule. And that's consistent with other cases that have relied on Sussman. And Sussman itself, to be clear, rejected an exception to the going and coming rule, not the going and coming rule itself.
So if we
Sussman,
follow the straight rule, it says if you're going to work, you are not acting on behalf of your employer.
that is the going and coming rule, Your Honor. And the fact that somebody has paraphernalia related to the work in the vehicle at the time that they're traveling to work does not turn that travel to work into something being done for the purpose of the master.
Obviously, there's a benefit to Mr. Ricketts because if he had to turn it in the afternoon, it would entail an extra trip. He would have to leave from where he completed his last job, drive it to the place of RWL or wherever to turn it in, go home, and then repeat the process to drive home. And unlike perhaps some of the panel members, I worked in Lee County during the season, and I served in Charlotte County during the season. I understand what the traffic is like.
Your Honor, and that makes the point that this was for the convenience of Mr. Ricketts.
I
Not,
understand. That's why the third factor talks
Yes.
about being in part or most part, or I'm sorry, I'm not paraphrasing, but that's why I wanted to ask. I want to make sure I was getting the flow of this.
there's other case law, and some of it was cited, I believe, in
Yes, sir.
brief, the Garcia case with the police officer, and there the court looked at, talked about the primary responsibility of the police officer. Of the
Yeah,
town.
they use the word primary. I noticed that in that
Yes,
opinion.
Your Honor, which would be relevant to the question you had. Here, the primary purpose of the travel was to get to work. Work had not started yet, like Mr. O'Connor noted. So for that reason, it fails the second prong assessment before the court would even get to that third part at issue. So if the court interprets Fierro as adopting Sussman and requiring strict compliance with those three prongs, they were not met here, as Mr. O'Connor noted, and I believe all the briefs went out.
I think Judge Campbell said we declined to extend the exception provided for traveling employees, you pointed out, and we choose instead to follow the reasoning of Sussman. So I suspect,
Your Honor.
as you say,
And Sussman
traveling
again
employee, probably Sussman
and Sussman rejected
to
it
reject.
as well. And that takes me to the second point I wanted to make, which is the two arguments on those two exceptions. They should fail. Fierro specifically rejected the traveling employee exception. And there's been no case law presented that the dual purpose exception applies in a tort case. And even if it did, this case is closer to Gilbert, where the lady was going to work. She was carrying the newsletter that she completed for her own benefit at home. She could have done it at work, but she decided to do it at home, and she was carrying it home at the time of the accident. And the Supreme Court said in that situation, when it's for the convenience of the employee, assuming the dual purpose exception would be relevant here, it wouldn't apply under Gilbert. And to the third point, I would just point out that it's not just a Coachman argument, Judge Northcutt. I believe some of the argument, at least in my brief, is that there's been a waiver and an abandonment here as to arguments related to employment status and agency status, and that for the reasons explained on the brief, here Mr. Ricketts was an independent contractor. And the initial brief itself on page 7 notes that he is not supervised by cable guys. If there's no supervision, if there's no control, this is an independent contractor relationship. And I'll conclude my presentation at this point.
Thank you, Mr. Lugo. Okay, we've got 10 minutes left to go. Ms. Klein, whoever, Mr. Dono, whichever one, if you guys want to speak.
Good morning, Your Honor. May it please the court, Michael Dono on behalf of Comcast. I believe Mr. O'Connor and Mr. Lugo have done a great presentation of the issues on appeal. And unless the court has any questions for me, Comcast rests on its brief and asks that the court affirm the summary judgment finding on all grounds.
Sorry, I was muted. Ms. Klein?
Yes, good morning. Hinda Klein on behalf of Capital Telecom. And I echo what my esteemed co-defense court relevant to Capital Telecom. I'll likewise rest on my brief.
Okay. Thank you. Thank you all very much. So this happened to me once when I was practicing law in a criminal case on appeal. We had about 6 co-defendants appealing our convictions. The docket clerk said we had to divide our 20 minutes among the 6 of us. And when we divided it all up, we didn't have 20 minutes worth. So, oh well. Right. Mr. Shaneen.
Thank you, Your Honor. In a wrestling match, normally there's an equal number on each side, but here I get all 4, and that's okay. But Your Honors, I'll jump right in where we left off. We were talking about Judge Casanueva, you were talking about the third of the Sussman factors, and I think everyone here seems to be in agreement that the Sussman factors is the correct overarching structure. This court has adopted it, used it, and I think we're all in agreement that it is the factors that the court should have looked at in making this decision. And the third of those factors says the conduct is activated at least in part by a purpose to serve the master. So that's the question. Is it a matter of law that nothing he was doing traveling from his home to the first stop of his journey for the traveling day was motivated in part for a purpose to serve the master? And I think the trier of fact has to be the one that gets to make that call. The Stanley case we talked about, and there they talked about the evidence adduced in summary proceedings, if believed by a jury, is sufficient to show that he was rendering a service for his employer. And here's the interesting part. Okay, we can agree that part of the decision to allow him to turn in the documents the next day is for the convenience of the employee. But let's look at that. If he doesn't have that convenience, if he instead has to travel those documents directly at the end of his day before returning home, is he on the clock? Yes, he is. From whatever location to the office to turn in those documents and to turn in the equipment, he is on the clock and he is getting paid. Here, he's arguably not on the clock if he's traveling from home to the office, if it's purely for convenience. So no, it's not convenient to travel around with office equipment. It's not convenient to return these documents. The business needs those documents by the next day in order to timely get paid for its work and to make sure that it gets reimbursed for equipment that it's not using. These are matters that are of purpose to serve the master, and it's not a matter of mere convenience to the employee, like, oh, if you want to fill out that form later at home when you've got more time, you can set it out on your desk. That's not this circumstance. Instead, this court should apply the Sussman factors.
So can I ask you how you understand what is accepting what? Is the coming and going exception to Sussman?
So yeah, Sussman, the general overarching rule of Sussman is that you aren't on the clock if you're not on the clock. If you're just
So
traveling
if
to and from work.
Sussman is the doctrine from which we're accepting, even if the third prong is met, if we agree with you that in part he was serving his master because even though that was the time at which he returned the work orders was purely a choice of his convenience. That still just gets us back to the coming and going exception to Sussman, right?
That's correct, Your Honor. And so the way that it would work is we apply the Sussman factors to find out if this employee is in the course and scope of his employment. And if you're traveling, you're only in the course and scope if you meet those three Sussman factors. And we believe that there was sufficient evidence when looking at inferences in favor of the employee that, actually not in favor of the employee, Mr. Ricketts, is a defendant here, in favor of the non-party to this employment contract. And that is why really it is tort law, not work comp law, that we have to look at all matters and inferences in her favor. And I think that's the real fundamental reason why it's still important to remind ourselves that this is tort law, that when we apply.
Right, so assuming that the Sussman test is met, then there's an exception to the Sussman test, which is that coming. Am I correct? That's the way you understand it. The coming and going is an exception to what would be resolved by the Sussman test, which is in the course of your employment.
I appreciate the question. And I think what's happening is there's two different overlays. That you have a tort way of looking at it and you've got a comp way of looking at it. And the coming and going is comp speak. But I agree with I believe it was Attorney O'Connor who was talking about how, or maybe it was Attorney Lugo, tort, when district courts look at these cases, they do look at these cases. They still see the reasoning, even if they don't necessarily apply them directly. And I think the important thing is in the tort overlay, we look at Sussman and its three factors, and those three factors wind up encompassing the going and coming rule. So the going and coming rule would say, look, if I'm Attorney Shanine, I'm traveling to my workplace and I'm coming back from my workplace and nothing about my travel is something that's of the kind that I was employed to perform. I'm not hired by my firm to travel to my firm, or that the conduct was activated at least in part by a purpose to serve the master. These three factors help us to understand the coming and going rule. It's not that the coming and going rule is an exception from or supersedes Sussman in some way. It's part and parcel of it. It's simply a different overlay. We can use the coming and going rule, or we can use Sussman. Both get to the same place. And that's when I talked about the hinge of this door doesn't swing based on whether we're in comp or tort. I prefer tort. My client prefers tort because tort makes more sense for a tort case. But at the end of the day, the analysis is the same because Mr. Ricketts was doing conduct of the kind that he was hired to perform by traveling around this equipment and work orders. The conduct occurs substantially within the time and space is authorized. And because the conduct is activated, at least in part by a purpose to serve the master, that you look at those three things. And once we satisfy all three of those, we have satisfied the coming and going.
Well, there's one condition preceding to the Sussman rule, if we can call it that. It says an employee. Does that mean we have to make a legal determination first as a precondition to going to that rule? Is the person an employee, or is that person an independent contractor? And was it appropriate on summary judgment to make that determination? Then if we determine that he is an employee or the fact is up, then we would move to the Sussman's rule?
I would agree with that analysis, Your Honor, that yeah, and that's why,
That's fine, because it's about the first time I've had to deal with this.
Well, Your Honor, I can't believe that's true given your body of opinions, but even if so, this court clearly understands, the nature of cases on summary judgment and why that standard is so exactingly high. And here, where the employment, we set out in the initial brief, all 11 of the factors that he was required to return the previous day's work orders, which were signed by the customers. The work orders add value to the defendants, that he was required to report to RWL. He didn't decide whether he wanted to or not. He was not provided with a weekly schedule, so he had to show up every single day. He was a servant. RWL and all of the ones below and above them were the masters in this case. He had to
I have
pick up.
one more question, and that's to see if you're all updated. I checked just before this OA, the case on summary judgment as to whether the Florida Supreme Court is going to adopt the federal rule has not been determined yet. Is that correct? We are still using our corpus, our body of law on summary judgment right now? Unless it came out last night. I didn't check last night to see if I'd missed it.
The appellate practice section is actually having its fall meeting of the bar tomorrow. And that is an item for discussion. We are all keenly interested in whether or not we might have a pretty seismic shift. But to
I
answer
just want to make sure I hadn't missed it, and just in case we can make a determination, and there's a motion for rehearing saying it's a different standard because it may be prospective or retroactive depending, and I just want to make sure I hadn't missed it.
It's important, and if it does come down before this court rules, yes, Your Honor, that will be a difficult issue on retroactivity. And if you'd like supplemental briefing, not that we really want the work, but we'll be happy to supply that if that were to come down. And that
Yeah, there's a difference between contingency and billable hours.
and unfortunately, I'm on the first of those, so I'm not looking for the work,
fixed
but
salary, you know.
that would be the third way of doing it, Your Honors. But so to Judge Casanueva's question, to sum up, currently the standards in Florida are such that summary judgment is only available when every fact and reasonable inference, if taken for the non-movement, still mean that the movement wins as a matter of law. Here, the court got that right in his discussion of the employment. He knew there was a question of fact on employment, but on coming and going, he asked for additional briefing, and ultimately he ruled that there was not an issue for the jury to decide. That's the error that we complain of, and that's the error that we respectfully request this court on consideration.
Well, I have a question about your hypothetical. If Attorney Shannon, back in the time when we used to go to offices and we used to use paper to file things, had brought home, had crafted the final draft had brought home the summary judgment motion, finished it at home, and needed to transport it back to the office in the morning because, you know, the runner was going to go serve it on opposing party. Does that satisfy prong 3?
I will tell you this, Your Honor. My first boss and a longtime mentor, John McDonough, always used to tell us before we'd leave, make sure to take a file home with you. You never know. And that's what he was getting to, is the idea that if you are, you know, bringing a file home and taking a file back, then you know what? Maybe we did, you know, have a reason that we were now serving the interest of the master. I would answer this: where there are questions like that, those are questions of fact, and those are questions that the jury should decide.
Okay.
So,
You used up your rebuttal time, Mr. Shanine. I thank you all very
Thank you
much.
all.
thank you, Your Honors.
The last group, I said the marshal's office would take you out, and then I got I wouldn't call it a nasty note from the marshal, who said, you're supposed to click the leave button. So click the leave button, you'll disappear, and then